In South Africa, a contract is a legally binding agreement between two or more parties that creates enforceable obligations. For example, in terms of a loan agreement, Party A borrows a certain amount of money from Party B or to Party B. In terms of that agreement, the parties need to know exactly what the intentions were in terms of the agreement, but also what obligations exist between the parties in terms of that contract. So a contract in South Africa is valid when all the essential elements of the contract are present, namely consensus, which is the meeting of minds between the parties. So the parties know exactly what kind of contract they're entering into. There's legal certainty in terms of the contract. So the contract needs to be certain in terms of the terms and conditions that the parties incorporate in the contract. Capacities of both parties need to be of a certain age to make the contract valid. Legality, the contract must be lawful. Possibility of performance, the contract needs to be possible to perform, and then there's also certain formalities that might be required depending on what the parties agree to. So in South Africa, a verbal contract is generally legally binding and valid, similar to that as a written contract. However, the requirements of a contract must be valid. So for example, a contract of sale where Party A buys a car from Party B. So in terms of that contract, the contract can be valid if it has been concluded verbally. However, both parties need to know exactly what the contract constitutes in terms of what amount of money Party A needs to give to Party B in order to have that car as his or hers, and then Party B must must stipulate to Party A exactly the amount of money that is required. So verbal contracts do pose significant risks regarding proof and enforceability. So for instance, if you borrow your car to Party B then test drives your car around the block, around the neighborhood block, and then enters into an accident. So in such an instance, it would be advisable that you have a written contract concluded to know which remedies are available to you in terms of African law. If one party fails to fulfill the end of the contract, it constitutes a breach of contract. So in such cases, the innocent party then do have certain legal remedies available to him or her that would restore them back to the position they would have been in if the contract itself was concluded properly. So in terms of, for an example, if a Party B breaches a contract that has been concluded with Party A might have certain remedies available to him or that he can institute in order to claim back the, the performance from Party B. For example, in terms of your Foschini account, so if you have a closing account, so the store would then claim back the money in terms of a letter of demand from the party that owes them the money. And if the party do not comply with that letter of demand, they can then proceed to take them further for suing them in terms of the contract. So in South Africa, you can approach the small claims court if your dispute is under 20,000 Rand. So what would happen is that I would then obviously proceed with legal proceedings against the party that you claim against, and also they would then create a standard letter of demand that will quicken the process for you to claim back the money that the performance from Party B. What you can also do is you can also approach legal institutions in South Africa depending on your financial situation and the nature of your dispute. So for an example, you can approach the Legal Aid South Africa, you can approach pro bono services, and then lastly, what you can also do is if you do have access to money, you can then approach private law firms.